On May 1, 2026, the Fifth Circuit Court of Appeals issued an injunction that immediately paralyzed the U.S. supply chain for Mifepristone. The ruling reinstated a medically unnecessary requirement that the drug be dispensed in person. Overnight, this effectively terminated distribution by mail and through telemedicine, severing access to the most common method of abortion in the United States. The following day, pharmaceutical manufacturers Danco and GenBioPro filed emergency applications with the Supreme Court. They directed their requests to Justice Samuel Alito, who oversees emergency matters originating from the Fifth Circuit, asking the court to stay the ruling and halt the nationwide upheaval. 2 years prior, in Alliance for Hippocratic Medicine v. FDA, the Supreme Court allowed Mifepristone to remain accessible via mail and pharmacy. The court dismissed that 2024 case strictly because the anti-abortion plaintiffs lacked legal standing to sue, leaving the underlying regulatory questions unresolved. In this new litigation, state plaintiffs like Louisiana bypassed the standing hurdle. They did so by exploiting a newly aligned executive branch, where the Department of Justice actively declined to defend the FDA's prior evidence-based rules. While the administrative dispute centers on FDA regulations, the legal mechanism freezing the supply chain rests on the resurrection of a 19th-century statute, one that forces a direct collision with modern First Amendment doctrine. This diagram compares the rapid timeline of the May 2026 litigation with the foundational architecture of the 1873 Comstock Act. The Comstock Act originated as a Victorian-era anti-vice law, explicitly designed to enforce public morality. The current federal code preserves this text in 18 U.S.C. Section 1461. The statute makes it a crime to use the U.S. Postal Service to mail any material deemed obscene, lewd, lascivious, as well as any article or thing designed or intended for producing abortion. A subsequent section, 18 U.S.C. Section 1462, broadens this restriction. It extends the prohibition to private carriers like FedEx, and following a 1996 amendment, criminalizes distribution through modern digital interactive computer services. For decades prior to 2022, the Department of Justice maintained a consistent interpretation of these statutes. The DOJ concluded that the Comstock Act does not prohibit the mailing of abortion medications unless the sender explicitly intends for the drugs to be used unlawfully. Applying the Comstock Act as an absolute nationwide ban requires abandoning that established DOJ interpretation. It weaponizes the literal text of a 150-year-old morality law against contemporary constitutional protections. This diagram maps the legal strategies used to revive Comstock. The first active branch is the originalist approach. This strategy attempts to bypass First Amendment protections entirely by categorizing abortion-related materials as historical obscenity. Under the 19th-century sexual purity standard championed by Anthony Comstock, abortion was legally conflated with vice, indecency, and the promotion of sex for pleasure. The constitutional counterweight to this strategy arrived in May 1957 with the Supreme Court decision in Roth v. United States. Roth explicitly rejected the Victorian-era sexual purity standard. The ruling established that the legality of a publication does not turn on the purity of thought it instills in the reader, legally severing medical procedures and healthcare information from the definition of obscenity.
For this originalist strategy to succeed today, the judiciary would have to completely dismantle 70 years of First Amendment obscenity jurisprudence and legally return to 19th-century moral definitions. This brings us to the second branch, the textualist approach. This strategy bypasses the obscenity debate entirely and relies on the plain text of the Comstock Act, which explicitly targets abortion materials and communications. Proponents argue that mailing these materials constitutes unprotected incitement to illegal activity, or aiding and abetting. However, that classification fails because abortion remains completely legal and protected in nearly half of all U.S. states. This flowchart outlines the judicial review process. Because the Comstock Act restricts speech based on a specific topic, abortion, it acts as a content-based regulation. That triggers the highest level of judicial review, strict scrutiny. To survive, the regulation must satisfy two mandatory prongs. It must advance a compelling state interest, and it must use narrowly tailored means. First, the federal government must prove a compelling state interest in restricting these specific communications. the government rarely prevails in proving that the suppression of a specific medical topic meets this bar. Second, the restriction must be narrowly tailored. A blanket federal postal ban is a blunt instrument. It restricts all related materials across the entire country, meaning it captures and criminalizes speech and distribution far beyond any targeted state-level bans. Enforcing the Comstock Act textually unconstitutionally suppresses protected medical communications and telehealth consultations across state lines, particularly where the underlying care is legally protected. Returning to the May 2026 emergency applications, Danco and GenBioPro framed their Supreme Court filings against this exact constitutional backdrop. The manufacturers warned that the Fifth Circuit's order upends a quarter-century of established, constitutionally protected distribution networks. It does so based on an unadjudicated statute with severe First Amendment flaws. In earlier litigation, the Department of Justice defended the FDA's evidence-based dispensing rules. Now, the DOJ maintains a strategic silence, actively refusing to defend the merits of its own agency's regulations. With the government refusing to defend its own regulatory power, the burden falls to private industry. The pharmaceutical companies' push to maintain distribution networks is the only active legal effort defending the validity of federal agency rules and First Amendment rights. This balancing scale illustrates the inescapable binary now facing the Supreme Court. Validating the Comstock Act as a de facto national abortion ban cannot be achieved through minor administrative tweaks to FDA protocol.
Upholding the Comstock Act requires one of two extreme jurisprudential actions. The court must either radically revert the definition of obscenity to 19th century standards, or carve a newly invented exception into First Amendment protections against content-based censorship. Either choice threatens the three core theoretical pillars of the First Amendment: the marketplace of ideas, personal autonomy, and democratic self-governance. The litigation over Mifepristone measures the First Amendment's actual power to block the government from using statutory relics to censor medical information and cross-state care.